Welcome to Washington Legal Foundation's web seminar. My name is Glenn Lambie. I am Executive Director and Vice President for Legal Studies here for the Foundation. For those of you not familiar with us, we are in our 46th year of public interest law, advocacy, and education on a pretty wide range of issues that affect the free enterprise system. Our sort of mission is to strive to create a legal and regulatory environment that is supportive of the conduct of business and innovation. This is one of the programs that we put on a regular basis. We also are very active amicus in the U.S. Supreme Court and the lower federal courts and state courts as well. The Legal Studies Division is kind of our think tank, and we do publications, programs such as this one, and we have an active blog. Check out our website at wlf.org if you have an interest in seeing more of what it is that we do. So while devices such as cellular phones and tablets have positively changed our lives by expanding the way we work and communicate, they also create challenges for business enterprises when those personal devices are used for work purposes. Under some federal and state laws and in many civil litigation and federal investigation situations, certain information from so-called off-channel communications must be retained, and failure to do so can come at a high cost. For instance, the Securities and Exchange Commission, in conjunction with the Commodity Futures Trading Commission, fined 15 financial institutions last fall a total of over $1 billion for failing to implement and maintain proper controls over business-related communications, including those made on off-channel devices. SEC is reportedly investigating private equity and hedge fund entities for such violations right now. Meanwhile, last month, the Justice Department updated its evaluation of corporate compliance program guidance to stress how prosecutors will consider practices on personal devices and messaging platforms when making charging and resolution decisions. We're pleased to be hosting today a presentation on these developments, which features two attorneys who have been closely following and writing on the agency's increased scrutiny of off-channel communications. I'll let you know that we're recording this program. If you have any questions that you'd like to ask, please do so using the Q&A function at the bottom of the Zoom screen. And also, our speakers are going to be doing a PowerPoint presentation, and I've put a link to a PDF of that in the chat if you're interested in downloading that. Joining us today is Hayley Trahan-Liptack, who's a partner in the Investigations, Enforcement, and White Collar Practice Group of K&L Gates, practicing in the firm's Boston, Massachusetts office. The practice focuses on government investigations, regulatory enforcement actions, internal investigations, white-collar defense, and complex civil litigation matter. She is very active in representing public companies, individuals, investment advisors, and financial institutions before various state and federal regulators and enforcement authorities, including SEC, Justice Department, and FINRA. Also joining us today is Chris Warner, who's an associate in the Investigations, Enforcement, and White-Collar Practice. This practice focuses on government investigations, regulatory enforcement actions, internal investigations, white-collar defense, and complex civil litigation matters. So let me share my screen, and we will get started with the presentation.
Perfect, great. Thank you, Glenn, for the introduction, and thank you for having us. Chris and I have been following this issue for a number of months, and I feel as if many of the things you just mentioned sort of came out in the last couple of months after he and I had started looking into the SEC's interest in off-channel communication and record keeping of the same. So it's a developing area. I think that many of us have been following the SEC's actions, and now DOJ and other entities are sort of getting on board. So we'd like to take you through what we've seen up until this point, some different types of communication that we see the SEC targeting, what rules they're using to target those types of communications. We'll walk through some of the enforcement issues and examination issues that we think are relevant today. I'm sure that many of you who are on the call are already aware of them, but we'll point out some additional things that we think are considerations we should be aware of. As Glenn mentioned, we do want to touch on some recent DOJ guidance that came out at the beginning of March and see how that will impact DOJ's examinations or DOJ's investigations going forward. And then we'll wrap up with some ideas on how you can prepare if you are a broker-dealer or investment advisor, before the SEC comes calling, and what you should be aware of if the SEC does come calling. And then hopefully we'll give you a chance for questions at the end. But please, if there's questions throughout the presentation, please feel free to put those into the chat. And I think Glenn will monitor those and dole those out where necessary throughout the presentation. So without further ado, we wanted to give you sort of an overview of where we are today, right? So we have seen increasing SEC actions since December of 2021. We've seen, obviously, the large charges that came out last September. And now we're seeing SEC sweep examinations following up on many of the initial record-keeping violations that were the main topics of the charges in September. But sort of orient you a little bit more, we think it's particularly important to think about the SEC's focus on this in the context of changing technology, right? So you have prior to the pandemic, you have an increase in the use of Slack, in the use of Teams, a lot of people who are starting to change their communication from necessarily calling on the phone to texting or personal email. And that had started before the pandemic. And we had started to see some movement from the SEC and from DOJ about concerns that that type of communication would mean that your records weren't going to be properly preserved, and that might hamper SEC investigations of other types of conduct down the road. But then that exploded, and that issue exploded during the pandemic. Suddenly you have a lot of employees who are at home, a lot of employees who are handling electronic communication on their personal cell phones. They're suddenly in an environment that's not well monitored. And you see a massive jump in the use of off-channel communication, non-email, not telephone, types of communication. And the SEC notices that it becomes a priority for them to track during examinations. And we see in December of 2021, the first record-breaking, or I don't know if it's record-breaking at that point, but attention-grabbing charge against a Wall Street bank. And then, of course, the ensuing investigations from there. So that's sort of to orient you where we're thinking about how technology is changing. Likewise, similar trajectory for DOJ. We had seen prior to the pandemic increasing questions from DOJ about what type of messaging policies companies had in place. Were ephemeral messaging, Signal, Telegram, WhatsApp, were those type of messaging encouraged by the company? Were they prohibited according to company policy? So sort of soft questions around that prior to the pandemic. And then post-pandemic, we're seeing a reaction to that. DOJ trying to communicate to companies a little bit more forcefully. These are our general expectations when we're dealing with negotiations and settlement. And this is what we think your compliance program should look like. So that gives you a little overview of where we are. Taking, I guess, even an additional further step back, Chris is going to walk us through some of our regulatory rules and what exactly the SEC is focused on and how these policies are being implemented. So, Chris, I'll turn it over to you.
Great. Thank you, Hayley. And hello, everybody. So the SEC has used two rules to primarily enforce its record retention requirements. I think the first one you'll see right here on the screen is Rule 17A4. And the SEC applies this to broker-dealers. And it requires broker-dealers to retain all communications and copies of communications relating to its business as such for a period of 3 years. I think the two most salient points here are 3 years in business as such. We are going to touch upon the business as such aspect and what communication falls under business as such later in the presentation. So I'm not going to spend too much time on that now, but I just would flag that. I'd also think that the unique thing about Rule 17A4 is its evolution throughout over the years. When it was first enacted, it was unsurprisingly applied primarily, and it was intended to apply to written communication. In the early 2000s, it was extended to email communication. And now here today, we see it being applied to these third-party messaging apps and for ephemeral messaging applications such as WhatsApp, Signal, text messaging, and the like. We can go to the next slide, Glenn. Thank you. So the second component, I should say, rule that the SEC has been using, and again, it depends on who the target entity is. It's the rule 204(2) of the Investment Advisors Act, which obligates any registered investment advisor or any investment advisor that should be registered to make and keep true, accurate, and current books and records of its relating to its advisory business. And if you actually look at the rule, it does describe a whole host of types of books and records that fall under this category, this rule here. But what we've noticed is that the SEC has primarily taken issue with, and you'll see it in the gray comment bubble below. They've primarily taken issue with originals of all written communication received and copies of written communication received that relate to any recommendation made or proposed to be made and any advice given or proposed to be given. So it seems like that component of this rule, and the specific component is it's 204-2 7I. That's what the SEC seems to be shoehorning this business-related communication into. That's what we've seen listed in the orders to date. So other considerations that we've noticed, again, this is not a focus of our presentation, but we did want to flag because they were mentioned in the SEC orders related to failure to retain this type of communication. And they're just basically the supervision, the requirement to supervise employees and that requirement, basically, these organizations failed to do that because their employees were not retaining the communication that they should. And again, it's not a focus of the presentation, but it's something just to have in the back of your mind, because the SEC has basically dinged all of these entities. And when I say all these entities, I'm referring to the organizations that were involved in the SEC's December 2021 settled action, and those 16 in its September 2022 settled action. So the SEC has dinged them with these failures. So we would expect them to also include similar. We'd expect the SEC to include these moving forward if they were to find further violations in additional companies.
It's interesting too. I think that you can't have one without the other. If you have proper management supervision of employees, and management is auditing communication, ensuring that employees are following the policies, well, you're probably not going to end up with a records keeping violation because you stopped it in your tracks. If they're not doing that, you're likely going to end up with both types of violations, both record keeping and failure to supervise, as we've seen in the order so far. So we want to make sure we go through exactly what these types of communications are, move on from the cut and dry rule. So we will take you through a couple examples of what the SEC has identified as what falls under these two rules. And then we're going to talk about the business related topic that Chris alluded to. So Chris, do you want to take what the SEC has done?
Yes. So regulators there in the SEC in particular is focused on ensuring that all business related communication is preserved. And I promise we will get into what business related means or what we think it means in the next slide. But that's their focus. They're not focused on every type of communication that occurs on these third-party messaging platforms, which is not all that surprising. They're not super concerned about your dinner plans with your buddy that also works in the financial services industry. But again, to that point, this business related communications, we've noticed that the communication that they've taken issue with has involved colleagues, clients, broker-dealer customers, and other persons connected to the securities, commodities, or swaps related business. And it kind of, I guess, ties into my last point about your dinner plans with your friend who also works in the financial services industry. It's they don't care about that, but they might be interested in, probing more into, are you sharing information with your friend, about a certain stock? And again, we'll discuss that more in detail as we move on. But that's just something to keep aware of, is that, you may think it's harmless communication with a friend of yours, that could actually lead to some issues down the road. And the mediums that we noticed at issue that they flagged were text messages, WhatsApp, Signal, and personal email. And again, I would also note that I think that this is what were noted in these orders, that being the December 2021 and September 22 order. But I don't think that this is limited to those 4 categories. There are tons of different ways to communicate, in ways of doing it, that I'm aware of that aren't on this list, and I'm sure there are others that I don't know of that are out there that people are using, and I wouldn't be surprised if that's similar to the majority of people listening to this as well. So in terms of business related, the SEC hasn't come out and specifically defined what that means, but they have applied the term, and taken issue with the following types of communication. So communication involving investment strategies, client meetings, and what I consider kind of the broadest category is communication involving the market, analysis, activity, trends, or events. So again, it's that can be broad. It depends on how they want to, I guess, decipher the communication, what it means. And I think that the SEC has been intentionally broad in its orders, to give them a little bit of flexibility, as to what actually qualifies as business related, and make it more of a case by case determination. Sorry, Hayley, go ahead.
Yeah, I think Chris mentions the SEC being intentionally broad. When you read the orders that have come out, there's no examples of trader A texted trader B the following: we think that is related to investment strategy, therefore this is a violation of the rules. It's much broader. So when we say that the SEC applies this to market analysis and activity trends, those are the language that the orders use, which makes it harder, I think, for players here to really look at the orders and say, yes, my communication falls within this, or no, my communication doesn't. It's much broader, and therefore harder to fully understand what's applicable, what falls under the requirements. Sorry, Chris.
No, and I think that's a good point too. And if you ever find yourself in a situation where you're dealing with the SEC on this topic, it makes it a little more difficult to predict exactly how they're going to handle it, or what, if they think that there's a violation, what sanctions they're going to impose, because it's tough to compare maybe the conduct that you're aware of to conduct described in prior orders when it's quite vague. But again, sorry, we can move on actually, if you'd like.
So I think we can go to the next slide.
Yeah.
So we've been alluding to talking more in detail about what these terms mean. So I think it's important to look at the 2 rules side by side, because a lot of people and market participants see these rules and say, the top one that applies to broker dealers requires communication relating to business as such. Now, that seems to be a lot broader than the bottom rule, which, applying to investment advisors, applies to advice given or proposed. And you see the other 3 categories there: receipt, disbursement, or delivery of funds, placing or executing orders, or performance. Business as such seems to be a lot broader. And we've had questions from people who are trying to devise proper policies of it seems like the SEC is relying a lot on the former, the more broad category, in many of the orders that have come out to date. And I know where there's a trade publication or a trade association letter from early January that addresses this very topic, that the rules for broker-dealers should not be applied to investment advisors. But what we see the SEC doing, if you go back one slide, thanks. If you see the reference to advice given or proposed, the SEC really seems to be using that as a broader statement of what types of communications relate to business. So if you start tracking this out, which we'll do in a moment, a lot of things can fall under advice given or proposed. If you take what Chris was mentioning earlier about market analysis, can that be related to advice proposed? If you're discussing market trends, can that be related to advice proposed? I think to any one of us, it seems like a tightrope to say that analysis of market trends is related to advice proposed, but do you really want to have that communication with the SEC, where the SEC has conducting an investigation, is looking at a number of text messages that haven't been properly maintained, or categories of messages that wouldn't be retained, and saying, having a discussion about whether or not that fits into one of these four categories. And we can go through a couple of examples. So in our best approximation of business-related communication here, Chris, what do you think about this one? We have Trader A asked, have you been watching ABC today? And then the other person responds, it's wild. Do you think it'll keep going up? What do you think? Do you think this is related to business as such, if this was were broker-dealers discussing this?
I think that I would, yes, and I would err based on how broad the SEC seems to be. I would say that it does, depending on obviously who they're talking to.
Yeah, I think that who they're talking to is a good point. If you're asking, have you been watching ABC today, and maybe you're mentioning it to your spouse, that's likely not business communication. But if you're saying, have you been watching ABC today, to a client or a colleague, and the next question from the person in blue is, I think we should get in on it, or other advice that that could relate to business. Taking it one step further, Chris, do you think it applies if these were investment advisors discussing this?
And yes, and I think for this example, I think that's a tougher call. I would think, based on the plain language of the rule, I would say no. But I think, to what you just mentioned, this conversation in the real world is not just going to end here. This person in gray has asked basically what does the person in blue think, and now presumably you're getting into advice given or proposed. So I mean, you would think that this person in blue would either answer yes or no, and then very possibly could provide reasoning why, and maybe a stance on their stance on the stock. And now you have an issue. And I think, Hayley, that goes to your point too about how that Rule 17A4 may appear broader than 204.2, maybe on paper, but in actuality, it's not necessarily going to be the case because of how communication just naturally flows.
So let's take a look at the next example. All right, we have person in blue says, hey, I'm doing a block of ABC. Let me know if you want details. And other person responds, interesting, I'll call you. What do you think, Chris?
I think this one is, in my opinion, is a little easier. I think yes on both accounts. Again, assuming you have the right players here.
I agree. I think that that makes sense, and this is a little more clear cut. But both of these examples give you a sense of how are you going to write your policy such that you're telling someone that, the first example is or is not related to business communication, and this example is. Just the fact that it's something that we can discuss and think about, as Chris and I sit here in this exercise of two lawyers parsing out fake communication, the fact that we can come up with a discussion about it. Do you really want to have junior employees, even mid-level or senior employees, thinking, all right, how does this relate to business? Where's this conversation going to go? Maybe I'm texting, my friend, the first one, and then my friend asks for, a former client asks for advice. Do I need to switch it to a business channel? Those are all questions that you want your policies to address and make it easier for your employees to know the answer before they start getting into this type of legal discussion that Chris and I just had. So we can move on to the next one.
Yeah, so I know I've been referencing these orders quite a bit, and Hayley and I have both discussed how the SEC has been pretty broad and vague in defining the communication at issue. And these two bullets on the slide, I think, evidence that these are taken directly from one particular SEC order, but the language is ubiquitous in all of them. They're, for the most part, pretty stock with very few changes. Between all, I guess, 17 of them, including the December order. And you'll see it's, again, communication at issue, messages concerning investment strategy, discussions of investment banking client meetings, and communication about market color analysis, activity, trends, events. And I guess in this one, they provided the technology industry. So they've, I guess, provided a little bit of scope, but not a lot to really make any difference. And then if you do go through some of the SEC orders, you'll notice that the examples they provide, the second bullet here, this is about as detailed as they get. Managing director exchange, off-channel business-related communication with colleagues, industry participants. Sometimes, they'll give you a little bit more color, but again, nothing specific, kind of general categorical terms of, positions or, roles in the financial security industry with who they've been communicating. So yeah, and I guess moving on from that, enforcement actions and exams, so we can talk about them a little bit more specifically and some of their implications other than the communication. Sure, as many people are aware, there's some pretty steep penalties that we can discuss. So the first time that we I guess the SEC made a splash in this was December 2021. They released a charge against a Wall Street firm, or I guess settled charges, for a penalty of $200 million, which is quite substantial. The order notes that the failures to retain the communication were widespread and pervasive, and that they spanned throughout the entire organization. They were at all employee levels. I would add that the SEC did emphasize that those individuals with supervisory authority or managerial authority or responsibility for implementing and enforcing record retention policies were themselves guilty of failing to retain electronic communication and violating the firm's internal policies. Again,
I imagine there's also a failure to supervise too.
Yeah, and a failure to supervise as well. And then again, the platforms that issue WhatsApp, texts, personal email. I would say that if you look at the quote from SEC Chairman Gary Gensler, it's pretty clear that, and this is again a quote that he released in conjunction with the 2021 order. He made the SEC's intentions is clear. To them, communication retention is important, and they're going to focus on it moving forward. I think that actually segues nice into our next slide, because they followed up on Gary's comments in September of 2022. And I'm sure as many people aware, it was the CFTC did it as well, but I'll focus more on the SEC piece. So again, 15 high-profile broker-dealers, one investment advisor. And again, the allegations were very similar in September as they were or I should say the findings were very similar in September 2022 as they were to December 2021. Focus on managers and supervisors, while also noting that the issue was widespread throughout the organizations. Again, they focused on kind of the pervasive nature of it. And then Hayley, I don't know if you want to talk a little bit more about the penalties and some of the remedial measures.
I think the penalties are important. We'll talk about how to prepare in a minute, but I'd like to flag these penalties because these are some examples of what you might want to do if you think you have a problem. Outside of reporting to the SEC, which is something that you might want to consider, these are things that the SEC thinks are best practices when there is a problem to require firms implement as part of their penalties. So having independent consultants review what their current policies are, instituting training and procedures, all of those are things that even if you have a problem now or you want to make sure your policies are in place, those are things that you could do now to make sure that your current policies are effective. Move on to the next slide.
Yeah. So again, the focus of the September 2022 efforts, I guess September 2022 efforts, were, the widespread and pervasive nature of this, as well as policy failures. All these actions that we looked at, there were policies about record retentions in place. The issue was they were not enforced, employees were not properly trained, and they were not effective. And you'll see that if you read some of the orders in, the remedial measure section and in the hiring of the independent consultant. What the SEC is getting at is basically ensuring that you have these policies, that they're in place, but they work, and that they're routinely evaluated and assessed to make sure that they are, moving and, modifying to, adapt to whatever technology is coming out there, how communication changes, and are they going to, capture this communication and retain it. The one thing too, I will note in every order, the SEC flagged that these firms had been subject to SEC inquiries. So I guess just by way of background, the SEC did a sampling for the 16 firms that were involved in the September 2022 settled actions. They did a sampling from 2018 to 2021, 30 employees. And they, in their order, they noted that during that time, these firms had received numerous inquiries from the SEC. And the SEC writes, they found that because there were these record-keeping violations that had impacted the SEC's ability to do their job, that impacted the firm's ability to completely and fully respond to the SEC. And they make that clear, and it's an isolated part of their order, which I think is intended to stand out, so people are aware of that.
Point. And we're seeing, since the September order, a number of reports that this is a continued focus, right? So we haven't seen anything as splashy as the September orders, but there have been disclosures by private equity firms and others that they have either received requests from the SEC, subpoenas from the SEC, inquiries from the SEC related to mobile phone use, inquiries related to messaging use. I'm aware of a recent private action where a firm decided to penalize individuals for failures to follow their policies, and not an SEC action, but again, a fairly newsworthy fine that they're imposing on their own individual executives. And then, here the mention of the French bank and the second bullet point in the bottom, that this is going to include requests internationally for entities that are registered in the US, regardless of where they might have businesses, which can get tricky if we start thinking about privacy interests with respect to GDPR or other countries' privacy laws, how exactly you're maintaining your communication and balancing those obligations with your SEC obligations. So we've talked about the SEC a lot, but we don't want to neglect that DOJ is interested in this too. And I know for many investment advisors or broker dealers, might not be as a challenging a landscape to know that DOJ is interested, but it's something to keep in mind if there are criminal issues, criminal investigations down the line of what DOJ also expects to see. Oh, as I mentioned at the beginning, we've been seeing this issue for a number of years of DOJ investigations, seeking communication that just isn't there because the employees conduct that type of communication through private channels, whether intentionally or non-intentionally, depending upon whatever the charges might be. DOJ has been alluding to the fact that they wanted to implement certain require or expectations for compliance programs for a number of years. The first real formal mention of it was in September of last year, what has come to be known as the Monaco Memo, which sets out different expectations that prosecutors should be looking at when they're evaluating a company's compliance programs or a company's policies. And third-party communication, third-party app use is not the primary focus of the memo, but it's brought up notably here. You see the clip on page 11 of the lengthy memo, but it is addressed within the memo that prosecutors should be aware of how third-party messaging has been used. Has the company been policing it? Does the company have policy and training surrounding what those requirements are? And again, this is nothing new. And for several years, I've received requests from DOJ to provide copies of what the company's communications policies are and what types of apps are used internally. But now prosecutors are being encouraged to consider that. There are additional comments at the FCPA conference in November. Again, DOJ is focusing on this, that they wanted to have a risk-based approach of what type of communication was actually happening versus, if that communication was being maintained, or understanding that DOJ cannot have the same record-keeping requirements that the SEC has. What type of guidance could the DOJ impose? And that was sort of an open question in November. Fast forward a couple months, and we have the evaluation of corporate compliance memorandum, which is a memorandum that DOJ issues every few years and updates it. It was updated at the beginning of March. And a central part of what that memo's updates include relate to off-channel communication and maintenance of business-related communication. When DOJ is looking at these issues, usually it's in the later stages of an investigation where DOJ is trying to negotiate some type of resolution with the entity. And prosecutors are encouraged to look to see what type of policies the entity might have in place that address both the issue at hand, and then are their policies up to date? Do they reflect the issues of today? And this is where this comes in. Are there policies in place for communication? Are policies being enforced? Is there proper discipline with respect to third-party app communication or off-channel communication? One thing both DOJ and SEC, which Chris mentioned earlier, are trying to prevent here is companies routinely using off-channel communication, and then they receive a subpoena from SEC, they receive a subpoena from DOJ, and they have nothing to produce. And DOJ and certainly the SEC don't want the response to be, all right, then there's no violation here because we don't have the communication. So part of looking at compliance programs is to make sure that a company's not getting credit for a compliance program that isn't up to date on its third-party record-keeping requirements. Now, important to note that it's a focus of both entities. So we are going to move now on to how to prepare. And I think this is a big topic. We only have a couple of slides on it, but it's certainly a topic that should be the front of mind of a lot of market participants. And the most important thing is to start now. We see that the SEC is continuing to have some sweep exams with respect to electronic communication. We know from the SEC's examination priorities that were released in February that the SEC is going to be looking at policies related to electronic communication. They might be conducting testing related to whether or not those policies are being followed. So it's part of the examination process that's going on now. Whether or not maybe you haven't been examined recently, that's something that should be front of mind as you prepare. Maybe you have been examined recently. The SEC, the window of record keeping is 3 years. So even if the SEC doesn't come calling until 3 years from now, the look back period is going to come back to 3 years prior. So it's important that companies know this now, start implementing the proper policies, and then beyond that, start making sure the policies are working and are being monitored, because you can have all the best policies in the world, but unless you're also looking at them and monitoring them, you have to show the SEC that you've been doing that portion of the policy too. Just a couple of quotes from the SEC about how important they view this as and how aggressive they want to be. They really want to send a message. So you want to show that the message has been received.
Yeah. And Hayley, I would add too, they've been pretty clear that, they put the market on notice and its participants that this is a focus and this is what they expect. And we've included some of those already in this presentation on prior slides. But I think moving on to the right, or sorry, staying on the slide, but another aspect too, sorry, Glenn, that was my fault. If we could just go back one. Something that the SEC has been pretty clear about is that the penalties for record retention violations are going to be big. And we've seen that 200 million, 125 million, 50 million, the smallest that I'm aware of being 10 million. And they've, as this quote here says, these fines are not going to just be a cost of doing business. They are taking this seriously. If you are found to violate these rules, there's going to be you're going to have to pay for it. And it's not going to be a slap on the wrist or a footfall type of thing. It's going to be substantial. Sorry, Glennon. Now we can move on. Thank you.
So
sorry,
a couple of these are, points that were articulated in the order. Obviously, review your current policies, make sure that they address these issues. Discipline is important. There has to be some bite And discipline doesn't have to mean termination, but it should be real discipline, because both for the firm's perspective, you don't want it to happen again, but you also want to be able to show the government we took it seriously and we responded as such. And that's discipline across the board, right? That goes from junior employees to senior employees. The SEC does not seem to be, it doesn't seem to care if it's a senior employee. They're not getting any special pass here. So discipline needs to be across the board. Routine trainings, of course. I think making sure that people know what these policies are and how they apply to the ever-changing types of technology. When you're writing your policies, you need to know that today the app of the day might be TikTok and Snapchat, but the app of the day 6 months from now might be some other, once TikTok is banned, some other type of communication that you don't want to have to change your policies every single time there's some new app. So make sure the policies are up to date and can account for the changes in technology. However, also make sure your policies change with the times and you're not something that's just on the shelf for the next 10 years.
Yeah. And Hayley, one thing I'll add to just on that point about the discipline is that as part of their remedial measure aspect here, with regard to the December and September orders, the independent consultant, or I should say, actually, no, it's not the independent consultant, but it's the entity is required for, I believe, 2 years after. So 2 years since the date of the order, I think that they need to inform the SEC of disciplinary action taken, which shows that they care about that, and they care about the firm taking that into its own hands and taking responsibility for that as well.
Good point. There's other things that, not outside of policies, practices that can be put into place that could help with making sure employees are following these practices, right? So you can prohibit certain downloads, you can prevent certain applications from being used on someone's computer. I think an interesting topic is company-owned phones or company-managed phones. Maybe 5 years ago, it was common for people to have, the company BlackBerry and the personal iPhone. Across the board, it seems to be more common now for a one company managed phone. Company pays for the phone bill, and all communication, is conducted on that phone. There's positive and negatives of having a company managed phone, but one of those positives is it's company managed. So you can restrict certain things, you can have certain monitoring software, you can build into your employee handbook that the employee consents to monitoring of their phone. So there's technology out there, and the SEC is aware of that type of technology. So coming to the SEC and saying, oh, my hands are tied, it was on their personal device, is not going to be a proper response when the SEC knows what types of options there are available, whether or not your policies contemplated them. And the last one is important. Chris mentioned the fact that the SEC did a sampling for these 16 firms they settled with in September, and that sampling went back a number of years. You don't want the SEC to be doing the sampling. You want to be doing the sampling and the audit yourself before they're coming around. So making sure that people are complying with this through your own sampling is important. So we have talked for a good 45 minutes. So we'd be happy to take questions from anyone on the call, or I think Glenn might have some questions of his own to the extent we haven't addressed them.
One general question that I do have is privacy. You had mentioned that with business issued devices, obviously the expectation of privacy is going to be much less, especially if they make it clear that you're going to be monitored. But in the context of like a bring your own device situation where it's used both for personal and for business purposes, how can companies best balance that? And is that something that SEC or CFTC and or DOJ is going to have to take into consideration as this sort of progresses forward?
So I'll answer your last question first. in our experience, we don't see a lot of latitude given by regulators for privacy. So, in the past, I've had examples where there's a request and we say, look, there's a lot of private communication on that personal device. I understand, we've imaged it, we have it preserved, but there's a lot of personal communication. And the DOJ and SEC's response often is, well, we don't care about that. That's not what we're focused on. We're not going to look at it. We're going to look at it in that it's there, but it's not our focus. So I don't see a lot of latitude in that respect. I think that, companies need to be aware of the risk both of what the government's expectations are. I don't think the government's expecting companies to monitor communications with one spouse, right? That's not what the expectation is. But how do you frame the murkier example that Chris and I went over of maybe my former client is a friend of mine and I'm communicating with them? So that is something that companies need to be, aware of the risk personally with employees, but the SEC is not as concerned about it. The other thing I'll add is, in some cases, using technology, different types of software can help diminish the privacy concern, and kind of counterintuitively, right? A lot of people understand that when I send something on my cell phone, it's being uploaded to the cloud. There's whatever technology process is going through it. We're not suggesting that a CFO is scrolling through the text messages between you and your coworker. Usually we're talking technology and type of technology that's flagging these things. So I think that can alleviate privacy interests in a little bit. I'm sure that is not the ACLU preferred answer, but I think that's kind of where we are now. I don't know if Chris, you have anything else to add?
No, I think that's right.
On the amounts of the fines in the fall of 2022, some commentators have said that it's not really clear how you can account for the amounts of the fines from one company to the next. Is that a concern going forward in terms of the standards that are set through the enforcement process? And should SEC and CFTC do a better job of making it clear as to why they decided to fine a certain company a certain amount and another company a certain amount if their activities were similar?
Yeah, I think we looked at the orders, and I'm sure as Glenn, that the orders are nearly identical, right? Across the 16. There's very limited differences. I think there are two, not being in the room when these were negotiated, not familiar with exactly what happened. Two takeaways. One is the size of the entities. I think you're looking at some of these entities have trillions under management, and some of them are much smaller. And the SEC has said publicly that one of the goals here, I think it was in one of our slides, is that we want to make sure that this is not just the cost of doing business. So the cost of doing business for Goldman Sachs is going to be a lot different than the cost of doing business for some smaller entities. So I think hypothetically, that could be one reason. The other thing is we see in all of the orders a mention that the firm cooperated, that there were good cooperation, good remediation, but we don't know what that exact cooperation was. I mean, there could have been different ranges of cooperation, and that's always the case when we look at penalties. And any type of penalty you can see varies a lot from entity to entity. So it's possible tips of cooperation or what they were willing to agree to could have played a role too, and probably will play a role down the road, right? Someone self-reports a violation, we're going to see a very different fine than if the SEC identifies something during an exam that turns into a 3-year investigation.
I would add.
I'm sorry, go ahead, Chris.
Oh, sorry, Glenn. I would add just to the back part of your question. It would certainly be nice if they gave a little bit more detail into the types of communication that were at issue, because I think, as we referenced earlier in the presentation, it makes it difficult for I guess us or an attorney in the position to advise a client as to what to expect the penalty would be, because you read these orders and they're all basically the same, but for whatever reason, someone got 10 and another person got 125 million. So it's difficult from that perspective, and it's tough too if you're negotiating with the SEC in a settled action to lean on these orders as precedent and be like, listen, you did this for this conduct, but here we have this X conduct, which is less than Y, and it gives the SEC certainly more leeway and more leverage, I guess, or I guess maybe not more leverage. It takes away our leverage in negotiation.
Did you or did either of you sort of get a sense from the settlements where there were situations where the supervisors who were supposed to be supervising and making sure that the internal policies were being imposed were themselves also not following the policies? Did you get a sense that were there some settlements that may have been a higher amount of money because of that? Could that be one factor as well?
I mean, I would expect that would be a factor if they were, conducting an investigation in part. I would expect that would come up during settlement negotiations. But from the orders, it was tough to get that sense for me, at least, because, I'll call it when their summary section, when they go through, they kind of list their examples of issues. In my opinion, and from what I recall, it seemed to be they focused on senior management. So they focused on managing directors, senior investment banking personnel, group directors, people of that nature. They weren't focusing, they didn't necessarily call out the, entry-level employee as they were kind of hitting the highlights of, their findings. It seemed to me that they were focused primarily on people with supervisory or managerial roles.
Hayley, any thoughts?
Yeah, I think it goes to that whole idea of tone at the top, right? Yeah, SEC cares a lot about that. And if your tone at the top is it's okay to message with people via text or WhatsApp, then you're not establishing and following your business practices.
Right. Just to stress, the Justice Department's guidance obviously applies in the situations that we've been talking about with SEC and CFTC and broker dealers and advisors, but it also applies in antitrust and other situations, correct?
Exactly. Yeah.
Okay.
And across the board, right? Any type. And I think it's sometimes challenging for some people who might be subject to an investigation to think, my investigation is about this widget. And then, at the end of the investigation, the Justice Department is asking, well, what do your compliance programs look like with respect to text messaging and record keeping? Those two seem very different. But the reality is the DOJ has a lot of discretion to negotiate settlements. And when you're starting to look at settlements, part of that is what your policies look like.
Another thing that DOJ stresses quite a bit is self-reporting of violations. Is that something that broker dealers and advisors and others that fall under SEC and CFTC's purview can do to possibly mitigate damages and fines in these situations?
Yes. So one thing I wanted to note, I think it's on one of their press releases, actually, maybe the September press releases, SEC says at the very bottom, if you have an issue with respect to electronic communication and record keeping issues, please contact us. And they provide their phone number. Obviously, that is a calculated decision on the part of any investment advisor, broker dealer. What is the extent of the communication issue? How pervasive is it? How many people are involved? Is it things like that are on the line that Chris and I talked about earlier, or is it very blatant? Have you been examined with respect to this? What the SEC say in the exam? So definitely depends upon the situation that you're looking at, but self-reporting is an option if you think that is a better option than responding to exam questions or otherwise.
So I'm sorry, Chris, go ahead.
Well, I was just gonna say I want to say I remember somebody at the SEC speaking in some capacity, whether it was when reflecting on in these press releases in December or September, or when reflecting on the 2022 year. specifically said self-report if you have issues. I could be wrong, but for some reason that's just coming to mind.
Do you think that this is going to be an area where you see a lot of whistleblower reporting to SEC by those who see policies are not being applied or there's no policies at all?
It's a good question. I can see, I think of the motivations of whistleblower. Usually, so you have monetary motivations. You can, if results in settlements, receive a portion of the settlement. If there's some type of issue with employment that can result in a whistleblower. I'm not sure that it other than the monetary issue squarely hits on what whistleblowers are usually after. But we seeing large penalties, so monetary issues could be substantial. I think there's also a lot of nuance because unless your firm is just not maintaining records, is it really worth going and making a whistleblower complaint over nuance or policies that might not 100% being followed? It's certainly possible, and whistleblower settlements are increasing every year.
And I would add to that, I think that for a number of companies, especially those that have kind of been ensnared in the recent actions, I would imagine they have pretty sophisticated data preservation and retention capabilities that may extend beyond the knowledge of the majority of their employees. And it may be more difficult for them to actually determine that there is an issue.
That's a good point.
So one final question. The letter that you referred to from the trade associations to SEC from the investment advisors, one of the concerns that they raise is that SEC not try to enforce internal policies, because those internal policies will often be stricter or more sort of broad sweeping than even the SEC's own sort of concept of what's business related. So does that deter companies from wanting to over comply or create compliance programs that will make sure that they sweep in everything that the SEC or other agencies want and then some?
So I think it's unlikely. I don't want to say unlikely. I don't think it's going to be a focus where your company you have a very, very broad policy. You have 95% compliance, and some, because the policy is so broad, you have some non-compliance. That itself would result in a large SEC action. I think you're more likely to see that on the exam side. SEC's testing what your policies look like, and perhaps you aren't complying with your policy, and that ends up being a deficiency in your exam or a topic for your exam closing interview. I'd be more, I'd expect that to be more common than the SEC launching investigation and then bringing charges down the line because you had this great policy, but you didn't fully implement it. Now, that said, the SEC does like to identify policy failures as part and parcel of other larger charges. So if there's other charges there, maybe you really aren't fully complying with the record keeping, and there are a lot of failures, and you also had a broad policy. And I can, not directly on point, but I can give an example of a company that I've worked with that had a really good policy, but not only were they not following it, they were also not following the rule. Not specific to this instance, but the fact that they weren't following their policy also became part of the settlement. But the primary issue was they weren't following the rule.
And DOJ has always made it clear that while we stress that we want you to have a great compliance policy and program, if you're not using it or enforcing it, it really isn't going to help get you any kind of benefit or plus in the process of resolution or settlements or other things. And that certainly seems to apply here as well.
Paper policy does you no good.
Right. Yeah.
Other than a paperweight.
Well, we've gone over a little bit. I hope everybody enjoyed the presentation today. Hayley and Chris, thanks so much for joining us and for the presentation and the preparation. This was being recorded, so if anyone joined us late or knows of anyone who might want to watch it, it'll be up on our website as an on-demand file later on today. And again, we'll also have the PowerPoint slides up on our site as well. Thanks again, Hayley and Chris, and for everyone joining us. And for those who celebrate, hope everyone have a pleasant weekend.
Thank you so much, Glenn.